The focus today. Oh, right, okay. I can maybe start again if you like. But hello, folks. Good morning, afternoon, evening, depending on where you are in the world. Welcome to this timely webinar. This is on the ITLOS advisory opinion on climate change and the law of the sea. We're focusing today on impacts on youth, climate justice, international law, and human rights. And so today's webinar has been co-organised by World Youth for Climate Justice and by the World Ocean Hub. So my name is Mitchell Lennon. I'm a lecturer at the University of Aberdeen in the northeast of Scotland. And I've been a researcher with the One Ocean Hub for around the past 5 years or so. And so today we're discussing the ITLOS advisory opinion, so the International Tribunal for the Law of the Sea, or you'll hear ITLOS or Tribunal during this webinar, and their advisory opinion on climate change, which was issued on the 21st of May this year. So just a bit of housekeeping as well. The Q&A is open, so feel free to participate in that. We'll try and answer some questions as you go, and we'll have ample time for questions too. And now the advisory opinion addresses a number of different matters, okay? And we're conscious that the many of our audience are sort of constitute youth and the general public, or indeed both, and those are people who are interested in this important development in international law and climate change and what it might mean for the future of the climate globally and future for the development of international law in this area. So just to clarify, the focus of this webinar today and the key topics that we're going to focus on are the relevance of the advisory opinion for intergenerational youth and youth climate justice, the kind of interplay and the relevance of the advisory opinion for the International Court of Justice advisory opinion on climate change, which is coming up relatively soon, and indeed the interplay and relevance of the advisory opinion on the Inter-American Court advisory opinion on climate change, when the hearings of that had just closed recently as well. So I'm your chair today, and we've got an excellent group of panelists as well. But before we get into that, I've been asked to kind of provide some context on the opinion before we dive deeper into discussions today. So to clarify, the advisory opinion was requested by the Commission of Small Island States on Climate Change and International Law, or COSIS, on the 12th of December 2022. And so the request asked, what are the specific obligations of states parties to the UN Convention on the Law of the Sea? So that's UNCLOS as well. You'll hear that term quite a lot in this discussion. To prevent, reduce, and control pollution of the marine environment that results or are likely to result from climate change, including ocean warming, including sea level rise, and including ocean acidification. And they also asked what are the causes, which are caused by greenhouse gas emissions into the atmosphere. And the second question that the COSIS asked was, what are the obligations under UNCLOS to protect and preserve the marine environment in relation to climate change impacts as well? So that's things like ocean warming, sea level rise, and ocean acidification. And so the commission itself, just for some background as well, the commission was concluded just over a year prior to that request on the 31st of October 2021. And then after that request, between 11th and 25th of September, just in terms of the questions there, I see if there's a video recording. There is one, and we're being recorded right now. There was a public sitting between 11th and 25th of September at the ITLOS in Hamburg, where the oral arguments of both COSIS, parties to the UN Convention on the Law of the Sea, and intergovernmental organisations were held, and there was a range of written proceedings prior to that as well. So that's some procedural aspects for you, and I won't take up too much more time, but as I said, the tribunal delivered its advisory opinion in May this year, and it confirmed a number of very important points and ones that we'll kind of unpack here and discuss and expand on in today's webinar. So not least, one of the most key points, I think, was that this kind of unprecedented recognition that greenhouse gas emissions into the atmosphere and ocean acidification are a form of marine pollution, so pollution of the marine environment. And the tribunals also underscored that states have obligations under the Law of the Sea, which are separate and additional to the Paris Agreement on climate change. And many of you in the audience will have heard of that as well. So separate and additional to their obligations under the Paris Agreement. And then further to that, the tribunal clarified that states have an obligation to protect and preserve the marine environment from climate impacts, ocean acidification, and they include kind of designating climate mitigation measures to minimize to the fullest extent possible the release of toxic substances into the marine environment, and exercising what we call a strict due diligence sort of standards to ensure that non-state actors are and industry and so on comply with mitigation measures, and that includes things like aviation and shipping and so on. And so we'll get a little bit more into all of these in a second. And then additionally, the tribunal underscored that obligations to prevent climate change related pollution affecting other states and the environment beyond national jurisdiction, that states have obligations to prevent harm to other states and to areas beyond national jurisdictions as well. And indeed that states should participate in global efforts to assist developing states, in particular vulnerable developing states, and indeed small island states as well. And then my final point as well, the focus today, or one of the focuses today, is going to be on human rights as well. So I've been asked to say, is this a rights-based advisory opinion, and is this an advisory opinion on human rights? And I'd say not quite, but it's not. It was focused on the obligations under the Law of the Sea Convention. But that said, the ITLOS did note that climate change raises human rights concerns, okay, and indeed climate impacts on the ocean raise human rights concerns. If anyone's familiar with some of the hub work, we're definitely raising awareness of that. And indeed, two judges at the ITLOS kind of separately confirmed that international human rights obligations are applicable to the protection and preservation of the marine environment from climate change, and that includes this obligation to prevent disproportionate impacts to those that are in vulnerable situations, particularly in kind of small and developing states and so on. So that's just a very short background. I think I've managed to keep to time, so pat on the back for the chair. And then my next panelist we're going to turn to, okay, I've got here is Zachary Phillips, who's counsel for COSIS as well. So Zachary, do you want to take it away? I've got about 10-15 minutes for you as well, so we can just have a bit of a discussion and back and forth if you like. You've got the floor. Thank you.
All right, thank you very much. First of all, thank you for having me here, and I'm grateful for being a part of this discussion for us to really dissect and look at the effects and ramifications of the ITLOS advisory opinion. Now, I'm aware some of the pressure of going first means that you can't say too much and you also can't speak too long. However, my goal today is really to speak about some of the key takeaways from our perspective being small island developing states, and also look at how those key takeaways from the ITLOS AO are beneficial and useful in going forward with the other advisory opinions. So a bit of background information. I am a Crown Counsel at the Antigua and Barbuda Attorney General's Office, which means one of the originating states that created COSIS, Antigua and Barbuda, were voluntold me to be a part of the work from the beginning of my tenure. So I've been involved with the COSIS process from the start, from drafting the question, drafting submissions, I even participated in oral advocacy on the days. And I say all of that to say that from our context, the ITLOS advisory opinion was a necessary part of an overall mosaic. In our view, these advisory opinions, ITLOS, Inter-American Court, ICJ, along with bilateral and multilateral negotiations and projects are the necessary pieces to the puzzle in order to solve the climate crisis. So we don't think that it's replacing anything. We think that it's just a necessary tool. And with that in mind, we think that this tool did exactly what it was supposed to do. So in our view, the ITLOS advisory opinion was useful in multiple senses, and the chair usefully did a synopsis of what some of the key takeaways were. But just for purposes of this presentation, I'll go over a few of them. In that, I think it was a key takeaway and a very useful and I would say inspirational result from the advisory opinion, that there was so much emphasis placed on climate science. And it is useful in the sense that for the advisory opinions or the legal context, the legal world, science for the most part is simply evidence towards a legal point. But it seems like with this advisory opinion, and hopefully with the others going forward, we see that science is playing a more central role in not just evidencing legal points, but in some instances, informing legal points. And that takes me to the next point, which relates to the standard of necessary measures. What are the necessary measures that states need to do in order to comply with their obligations under UNCLOS? And we see that the ITLOS advisory opinion spoke very clearly to due diligence being an objective standard. But how do we measure that objective standard is through the best available science. And I think this is a really key and useful point because it also indicates that the standards of how we keep our obligations will evolve just as the science evolves. Using a more literal example, at the point in time when UNCLOS was created, there wasn't an idea, an understanding of how dire the climate crisis was. There was an indication, yes, we were aware that there was damage being done, but we didn't understand the direct effects in the understanding that we know today. But that doesn't mean that because the treaty was created in the 80s, that our obligations are somehow crystallized based on our understanding of the 80s. And I think that's a very useful takeaway that will be, I'm sure, will be repeated and echoed as we continued in the other advisory opinions. Coming from a legal background myself, another very, very useful, I think, excellent point that the ITLOS advisory opinion gave us was that the Paris Agreement is not lex specialis. And the term lex specialis would mean that it is an area of law that is governed by specific rules. There are some states who are making this argument that climate change has its own unique rules, and we should only look at those rules when we're dealing with questions of legal consequences, obligations of states, even human rights. But the ITLOS advisory opinion has clearly stated that while the Paris Agreement and the UNFCCC regime exists, it is not solely responsible for the obligations in relation to the climate context. And that is an excellent, in my view, that is a win. That is a win that we already have got, and we will continue to build on as we continue with the other advisory opinions. So switching to the context of how these results are useful for going forward with the ICJ, especially for small island developing states. Funny enough, I was in a coordination meeting yesterday, speaking to how we would move forward as the CARICOM region in our submissions. And we noted that most of the counter arguments against the result that we want to see as small island developing states can be grouped into four broad topics, broad statements. So the first statement is, climate change and its adverse effects are too complex to attribute to any act or omission of states. So what I'm highlighting here is this is a counter argument being made by certain states that don't want to see an evolve of the rules that surround climate change. Now, why this or how the ITLOS advisory opinion helps with rebutting this is that we've already seen by the judgment of the ITLOS AO a clear identification that the Paris Agreement UNFCCC regime is not the only regime that is necessary to identify the obligations of states. So in response to a suggestion that climate change is too adverse, too complex, the simple response is obligations exist in a multiplicity of areas that can be attributed to the actions of states, whether it's dealing with climate change, whether it's dealing with ocean governance, whether it's dealing with human rights. So that's basically knocked out of the water. And I'm going to say knocked out of the water a lot. I know it's a bit on the nose, but the next statement that we've gathered as a focal point for counter arguments is the court should not interfere with negotiations under the UNFCCC regime. Now, while it is not directly referred to in the ITLOS advisory opinion, but I do think this statement, again, relating to Paris Agreement not being lex specialis is a response to this argument. And I also noted when I started this presentation that the ITLOS advisory opinion, the Inter-American advisory opinion, the ICJ advisory opinion, they're all pieces to a puzzle, and the puzzle itself is resolving the climate crisis. So it is, to my mind, not a valid argument to say that we shouldn't interfere with another regime. In many other statements, I always use the equivalent of when we learn international law. We normally have a pill lecture first thing in the morning, and then 2 hours later, we have environmental law, and then later on the next day, world trade law. But that's not how it operates in real life for states. And especially with small island developing states, literally in my office in the Attorney General's chambers, there are 3 persons who deal with international obligations. All of Antigua's international obligations are responded to, managed by 3 persons. So we really know those states that do not have the luxury of having large civil services, we really know that they all interplay with one another. And the final point that I would like to raise here is that a lot of states that are counter-arguing the progress that we are hoping to see have raised that the conduct that has caused significant harm to the climate system does not carry any legal consequences under the law of state responsibility. And this is useful because this is not useful. The ITLOS AO is useful because even though it doesn't directly address this question in a way that I think may have been, I would say, more helpful going forward with the other AOs, I think it does enough. Because there's a specific reference that I want to read verbatim that is made by the ITLOS AO that says, forgive me 1 second, right. Diffuse and cumulative causes and global effects of climate change would make it difficult to specify how GHG emissions of one state cause damage to other states. But the tribunal did emphasize that it has more to do with establishing the causation for purposes of state responsibility than the applicability of that obligation. So what that means is discussing about the difficulty of causation and linking GHG emissions to specific results is, in fact, a difficult question that the ITLOS AO acknowledges, but it does not mean that the law of state responsibility is inapplicable. And that has been confirmed in the ITLOS AO. So to my mind, we also are able to knock that out of the water. And these are really the more crucial undermining arguments as we head forward with the other advisory opinions. So in my view, the ITLOS AO does help us give a strong foundation to respond to any other counter arguments that we see. So with that, I'm going to pass on to my other panelists and look forward to hear more discussions on the matter.
That was excellent. Thank you very much, Zachary, and also great to hear from somebody who just the whole the fact that you've been involved with it for the entire timeline of this, and you have all this institutional knowledge. And thank you so much for sharing that with us, and definitely doing it in a way that our audience will be able to understand, regardless of their background and so on. I thought that was great, and indeed, I think the discussion on the fact that the advisory opinion is just one piece of this regulatory puzzle is really, really important. So thank you so much for that. That was great. Okay, so next up we have Joey as well. So I don't know if you want to just introduce yourself and tell us a little bit about SEAL as well, and then we can go into your kind of thoughts on the AO. That would be great. Thanks so much.
Absolutely. Thanks a lot, Michelle. I'm Joey. I'm a senior attorney at the Center for International Environmental Law. As an organization, we have been involved with the 3 climate advisory proceedings before different international tribunals. Yeah, pretty much from the start. From the start of the actual requests. So yeah, I'm very happy to be here today with all of you, and many thanks to World Youth for Climate Justice and also One Ocean Hub for putting this discussion together. One of the things, and I think Zachary's laid the groundwork for this very well, but I would want to focus on in my comments today, is how the ITLOS AO can influence the ICJ AO. As we know that a lot of our focus now, there's the Inter-American Court one that is extremely important, and Alana will be making the links there. And the ICJ one is coming up. The hearings are, supposed to be scheduled early next year. So very much we are looking to the ITLOS AO to see how we can strengthen climate justice focused outcomes from the ICJ. And the ITLOS opinion is excellent in many ways, hopefully sets the floor and not the ceiling for the ICJ AO. The tribunal's unambiguous guidance to protect and preserve oceans from drivers and impacts of climate change is very relevant for climate justice, the rights of present and future generations, and I would even say our very survival. Then ITLOS is the first of the 3 international courts, the International Tribunal for the Law of the Sea, the ICJ, and the Inter-American Court of Human Rights, to deliver its opinion. And so its findings are expected to provide critical guidance to the forthcoming climate advisory opinions, which will come within the next year. And the ocean as a critical component of the climate system and environment is clearly within the questions which have been posed to the ICJ, which there are two big questions. One is on what are the state obligations in relation to climate, and then what are the legal consequences for breaching those obligations. And notably, the resolution requesting the ICJ for an advisory opinion on climate expressly talks about the UN Convention on the Law of the Sea, UNCLOS, and the duty to protect and preserve the marine environment. And as a preeminent authority on the law of the sea and the first international court to weigh in on state obligations in relation to climate change and oceans, ITLOS can both specifically inform the ICJ to understand states' international duties to protect the oceans in context of the climate crisis, but also more broadly how the ICJ will define state obligations regarding climate change to ensure the protection of the climate system and other parts of the environment for states and for present and future generations. So there are many fundamentally important aspects, and I think between Michelle and Zachary, we've touched on them. But just to kind of re-emphasize, this issue of applicable law that both Michelle and Zachary mentioned is absolutely critical for the ICJ. It is a key contentious issue, and basically, as has been talked about, it comes down to, do the climate agreements, the UNFCCC and Paris, exclusively guide the interpretation of state duties in the climate context, or rather is it multiple sources of international law which define and inform the scope of state duties? And the answer is, as Zachary has mentioned, these agreements, the climate agreements, are relevant to the questions before the court, but their limited scope does not allow them to fully answer those questions. States have concurrent obligations under multiple existing sources of law, including, for example, the law of state responsibility, customary and conventional international environmental and human rights law, the law of the sea, as ITLOS has pointed out very clearly. Climate change is not just an environmental problem. It has cross-cutting effect on society and all areas of the law. No one legal source can fully respond to the complex interlocking dimensions of climate change and the myriads of ways in which climate change affects public and planetary well-being. So immediately relevant in the ITLOS AO, and there's some beautiful language in the decision, which I will not read to you, but I encourage you to go read, on the concept of systemic integration of international law. And in line with this, as has been mentioned, and this is very, very important, just by fulfilling the obligations contained in the Paris Agreement, states do not meet their international legal obligations related to climate change. This is an absolutely central finding of the tribunal, and one we very much hope that the ICJ follows and builds on. As he mentioned, this will be essential to deliver climate justice-oriented outcomes for present and future generations. Also, and I 200% agree with Zachary on this, is ITLOS, the ITLOS AO's focus on the importance of the best available science when setting out the scope of state obligations in relation to climate change. What is important that it's not just something to be considered or taken into account, but it's something that states need to reference when they are setting laws and policies at the national level. The number of times the ITLOS AO mentions best available science is really interesting. Like, you can run a search and it comes up so many times. And what is really important to kind of marry this with the due diligence obligations, states often take this to be like, well, yes, of course we should take care, but we have the discretion to set whatever measures we want. And of course, states have that discretion, but it is not unfettered. This point that Zachary raised, the ITLOS AO, is very important to support the argument that state measures to address climate change, including legislative, administrative, and policy measures, and the margin of appreciation afforded to states as regards the means chosen, must be bounded by considerations of best available science. This is absolutely critical, and we really hope that the ICJ builds on this. It also very much said that to meet their legal duties in relation to climate change, states must adhere to a stringent standard of care, a heightened standard of care. And by care, it's the necessary measures that you have to take to reduce and prevent and control marine pollution that arises from GHG emissions, but also more generally, state obligations in relation to climate change. So their due diligence findings are very, very important and key. Other critical aspects, and we won't get into this, but are really important for the ICJ include equity, the duty not to cause transboundary harm, the precautionary approach, and obligations that states must consider could be engaged when there is the use of certain risky, speculative, uncertain technologies, such as, for example, marine geoengineering. And to take that into consideration, that if there are certain types of effects that come about because of the use of those technologies, then their legal obligations will be engaged under UNCLOS. And also to keep in mind that while this opinion offers strong and progressive interpretation of state obligations in relation to climate change, there are key areas where the forthcoming climate advisory proceedings can and should go further on. For example, the future opinions can expand on how international human rights law defines the precise scope and content of the state obligations. And perhaps this was left appropriately to the Inter-American Court of Human Rights that is looking into this and the ICJ. And also the question that ITLOS did not squarely reach, but did make some useful references on, which is what are the legal consequences that arise when international obligations are breached? This is the second question, the entire second question before the ICJ. So that will be really important to focus as well. One of the questions that the organizers asked me to quickly respond to as well was, how will states have to conform and what legal consequences will they face for breaching their international obligations? Very quickly, in clarifying what the law means, AOs provide guidance to states and courts alike, influencing decisions about policy and legal proceedings. But what is important to remember is the power of law is not only in its enforcement when disputes arise, for example, in contentious cases, but it is also in its capacity to prevent such disputes from arising in the first place by aligning understandings of what conduct is permissible and required. So going forward, we really hope that states draw on the ITLOS AO, draw on the other forthcoming AOs to guide their action and ensure that they comply with their legal obligations under international law. Under the ITLOS AO, the tribunal does underline, it doesn't really go into questions of liability, and it says from the start that it will not, it did not interpret its mandate to do that, but it does mention in the text itself that a breach of obligations under UNCLOS would engage the international responsibility of that state. And that finding paves the way for the application potentially of the law of state responsibility to the context of climate change and could definitely be built upon by the ICJ further. And the tribunal's brief reference to international responsibility does have that potential relevance that the ICJ could build on. And such legal consequences, for example, under the law of state responsibility, could entail cessation of wrongful conduct and guarantees of non-repetition, as well as the provision of full reparation. That could be restitution, that could be compensation, rehabilitation, and measures of satisfaction. Another question, and then I will end with this, is on how the AO could influence the creation of mitigation and adaptation measures, and what could be the practical implications of ITLOS and ICJ AO for individual people and climate negotiations. So very briefly, the three AOs together, and I do think once they're all delivered, they will have to be read together, represent basically a once-in-a-generation opportunity for international judicial bodies to clarify state responsibilities to confront climate change under international law, and this could have ripple effects for decades to come. There is something that is often said, oh, AOs are not binding, but they are authoritative interpretation of binding international law in many cases, so they carry great legal weight. And the ITLOS AO will undoubtedly, along with the other two forthcoming opinions, influence other courts' interpretations of state duties, and thus rulings in pending and future cases, as well as developments of laws and policies around the world. Moreover, as Zachary mentioned, they're not at all in conflict with climate negotiations. They may, in fact, help cut through political inertia that has long stalled progress. Those of us who are at COPs, we know how extraordinarily weighed down that process is by politics. And this, by providing clarification, by giving negotiators from global South states, from small island states, climate vulnerable nations, additional legal tools to bolster their positions and needs, this could potentially provide a firmer basis for multilateral solutions. And in my heart, I mean, I come from West Bengal in India, so we're next to the ocean. I am very hopeful that the ITLOS AO will bring oceans to the forefront of climate negotiations and discourse and action in a way that we don't see really right at the moment. And in clarifying states' legal obligations, this is really important. The AO has in ITLOS and hopefully will continue to say that yes, states have discretion to set measures, but this is not unfettered, that there needs to be objective criteria to set this. And while these AOs may not set out specific sectoral policies in details, what they can do is lay out a blueprint and assessment modalities for compliance. And this will be critical for national level legislative and regulatory conversations, which will have impacts on kind of people's everyday lives and individuals. And the last thing I'll mention, that the processes themselves can provide a platform, and they are, to draw attention to the toll that climate change is taking, to highlight the frontline experiences with and leadership on climate, to mobilize civil society actors across climate and human rights spaces to shape the narrative and demand that public and private actors bring their conduct in line with their legal duties and what science and justice demand. I'll stop here, Michelle.
That was brilliant. Thank you so much for that. It was again incredibly comprehensive, and I am really enjoying this webinar as well. I'm trying not to just sit with a big grin on my face, because I think I can see how we're just building and building and building on this and answering some key questions. And now I've just made a note as well, just about the advisory opinion and how that might influence climate negotiations as well, because I think if we maybe have some time towards the end at questions, we can maybe discuss that, because I think a lot of our audience will be familiar with the UNFCCC process and the slowness of it as well. And then just a housekeeping point as well. You know, the Q&A is open as well, audience. So you're awfully quiet at the moment. So if you want to kind of, if you've got any burning questions at the moment, feel free to pop them in the chat, and our panelists will be able to answer them. But anyway, just turning now quickly to Alana as well. Alana, do you want to introduce yourself and now kind of begin to kind of answer some of the other burning questions that we have for this webinar? Alana, please.
No pun intended, Mitch. Good afternoon, morning, evening, wherever you are. My name is I'm a lecturer in international environmental and international energy of the law, University of the campus, and I'm also head of Caribbean Environmental Law Unit.
Like we're having some technical issues here. Let's see if they resolve themselves like Zoom always used to do. Alana, how are you getting on? Oh, yeah, okay, that's all clear. So let's see.
Okay.
That's better.
Oh, did I go somewhere? Sorry.
Yeah, you cut out for a second there. Yeah, you seem to be fine now. I think other people have put their video off, so I might just do that as well.
Okay, I'll put my video off too.
I think, well, okay. Well, I think you're fine, but yeah.
Okay. Okay, so I was saying I will focus my presentation, on perspectives of human rights, and then look at the perspectives in the Americas, and specifically in relation to the Inter-American, the request to the Inter-American Court on Human Rights. So the first thing that I was asked to address was that even though the tribunal mentioned that climate change represents an existential threat and raises human rights concerns, it did not elaborate on this. And therefore, whether the advisory opinion was a helpful tool in the protection of human rights. I think the first thing to recall is that with respect to human rights, the mandate of the commission, of the tribunal, primarily deals with issues such as concerning the Law of the Sea Convention and its instruments. And as mentioned by Joy, the ICJ will examine the issue in broader context, such as state responsibility, law of the sea, climate law, and so on. However, so while many courts and tribunals and scholars have established that there are important human rights linked to the ocean, which climate change threatens, the court may have decided to leave the elaboration of these concerns to courts whose purview is mainly human rights. So this includes courts such as the European Court of Human Rights, the African Court on Human and People's Rights, and of course, the Inter-American Court on Human Rights. This court, so the Inter-American Court of Human Rights, is already trailblazed in Advisory Opinion 2317 and raised human rights linkages to the wider Caribbean region as provided by the Cartagena Convention. This advisory opinion already made linkages between the marine environment and the human rights, which we can now link to what the pronouncements on science and other things which ITLOS has said. I want to also highlight that the court has given important perspectives on children's rights and youth climate justice. This court, I mean, is Inter-American Court. It has recently endorsed General Comment 26 on children's rights and climate change in the La Arroyo case. And this is of added significance within the Americas, given the current demographics and of the region. That is, Latin America and the Caribbean currently has the largest number of children and young people aged 10 to 24 years in the history of the region. So there are important repercussions for marginalized demographics and the principle of intergenerational equity. One of the many things that ITLOS would have clarified, and now turn into how the advisory opinion can address the protection of the rights of coastal and small island communities. Now, one of the things ITLOS highlighted is, as mentioned by Mitch and Zachary, are that greenhouse gases, emissions, and acidification are forms of marine pollution, and these can be from land-based vessels or aircraft. And these need to be addressed through individual action and participation in global efforts to address climate change. Now, within the Americas, these pronouncements take on additional meaning as the wider Caribbean region, which is the combined bodies of water of the Gulf of Mexico, the Caribbean Sea, and part of the Atlantic, are considered a semi-enclosed sea. And as a result, UNCLOS of itself requires additional cooperation under the law of the sea, and which, given the pronouncement of UNCLOS, will include efforts at the ocean climate nexus. Additionally, as Zachary would have explained, SIDS are small island developing states. SIDS are a special group of states united by remote economies, and they're prone to natural disasters and have long been recognized for both their environment and development challenges by the Rio Conference. Now, these small island developing states are spread over the Pacific, the Atlantic, Indian, and Ocean and South China Sea, and also the Caribbean, which falls within, of course, the region of the Americas. So there are 16 small island developing states in the Americas. And the role the ocean plays to the climate mitigation is even more important for these states. And I offer 3 or 4 reasons for this. The first is that for the vast majority of Caribbean small island states, they are ocean rich in nature. As on average, the ocean under their control is 28 times their land mass. So putting this into perspective, these states are what we call large, or prefer to be looked at as large ocean states, So for example, Barbados, where I live, has an exclusive economic zone 388 times its land size. And Antigua and Barbuda, from which Zachary hails, is 250 times its land size. Therefore, it is easy to see that the continental shelves exclusive economic zone, and therefore the marine space, comprises the lion's share of natural resource capital for these states. This was underscored and highlighted as a recently concluded Small Island Development Conference, where in the outcome document called the Antigua and Barbuda Agenda for SIDS, it was specifically emphasized that the ocean is critical for sustainable ocean-based economy. Another critical factor is that because of their smallness of size, SIDS needs to manage their land as well as sea, marine aspects as an integrated mass. And this is on the approach, what we call the Ridge to Reef approach, which is essential for comprehensive and effective management. And I take us back to UNCLOS, the tribunal, the ITLOS, mentioning that pollution can be both land-based and marine. So this reinforces this approach. And the Inter-American Court, in their advisory opinion 2023, has endorsed this approach and given guidance with respect to the Cartagena Convention area in the wider Caribbean region. I want to also add that the states in the Americas, we also have diverse coastal marine environments, which are called blue and teal carbon ecosystems, which have been recognized since 2006 by the Intergovernmental Panel of Climate Change for their importance in mediating the impacts of climate change, as well as a critical component of nature-based solutions to climate change. Additionally, these ecosystems are linked to enhanced fisheries and other key important activities such as tourism, aquaculture, and mariculture, which are all fundamental to states of the Americas, and which states have been utilizing, some states have been utilizing in an effort to address their crippling foreign debt, so which in turn impacts their resilience to climate change and other disasters. So for example, we see Belize and Barbados embarking on debt for nature swaps, and Barbados in the near future hoping to embark on a debt for climate swap. So how can the Inter-American advisory opinion potentially build, or how can the advisory opinion from ITLOS influence the Inter-American Convention? The advisory opinion from the Inter-American Convention, which we expect either later this year or early next year. My feeling is that the advisory opinion provides a clear opening for the Inter-American Court to further expand on human rights, which arise at the ocean climate nexus, and to clarify human rights standards with respect to connections between land and sea in the context of climate change. As I mentioned before, this has already been done in international courts, such as or international bodies, such as the Human Rights Council, in the Torres Islands case and the Toyota case. And in our submission to the court, we have argued that the court can further develop a harmonious interpretation of the law of the sea, international biodiversity law, together with international climate change law, human rights, and children's rights law. Already, we see that the court's jurisprudence and advisory opinion 23 of 2017 and the Arroyo case are important litmus tests to this effect. And it is firmly established that the human rights, and as we have already established that the human right to a healthy environment includes a healthy ocean, we therefore argue that the court has the opportunity to link this to the role of the ocean in the protection of human rights to culture, children's human rights to play, everyone's rights to food, rights to life, health, and livelihood. Importantly, therefore, the court's advisory opinion will allow for a further clarification of the context and obligations arising from the human right to a healthy environment, already recognized as an autonomous right in Advisory Opinion 2317, when addressing threats from the marine environment in the wider Caribbean region. I will also mention that the Inter-American Court has already endorsed the Ridge to Reef approach in the Advisory Opinion of 23 of 2017. And there are already examples of state practice in consonance with the Paris Agreement's nationally determined contributions by states in the region. For example, Barbados has implemented the Roof to Reef program, as well as other states in the Eastern Caribbean have implemented the Ridge to Reef approach. This includes St. Kitts, for example, which they have linked to their man and biosphere program. So again, we see the link to the right to culture. Finally, I hope the court expands further on the role which Indigenous and Afro-descendant peoples and local communities will play in the management and conservation of biodiversity and areas beyond national jurisdiction. And this is a clear linkage, obviously, to the International Tribunal, to the law of the sea. Now, there are potential to expand on the principles of equity, participation, and benefit sharing contained in the BDNJ agreement. Additionally, the court can make stronger statements on the role of ocean and climate defenders, which is really of importance in the Americas, because this is the region where defenders are most under threat. And this includes youth defenders, which we have seen on the rise. And the court can also make stronger linkages to instruments which provide protection for defenders, such as the Escazú Agreement, as well as instruments which underscore economic, social, and cultural rights. And in this respect, I reference the Protocol of San Salvador, for example, and within the Caribbean region, we have the Caribbean Charter for Civil Society. So these are just some of my preliminary thoughts, and of course, I would be delighted to speak further or to answer questions in this regard. Thank you. Mitchell?
Brilliant stuff, Alana. I managed to unmute myself first before I reappeared on the screen there, so apologies, but that was great. And it's thank you again for bringing another large ocean state perspective to all of this, and indeed, you know, kind of clarifying what we think the Inter-American Court will bring. What piece of the regulatory puzzle will they be? And so that was all excellent, and indeed kind of summing up some of the hub submissions to the Inter-American Court as well. So I thought that was excellent. Okay, so and again, last but not least, and we've got Eula as well. So we've had the pleasure of meeting before, Eula. So Eula's also an Aberdeen alumnus, but I was not a student of mine, I have to say. So it's great. It's great to have you here. So you've got the floor then for another 10-15 minutes or so, or as long as you like. Thanks very much.
Thank you so much, Mitchell. And I like that you said she's not a student, so whatever of mine, so whatever she's going to say, if it's not correct, it's not my fault.
No, I don't think it was that. I think it was more, more that I'm not responsible for your success in any way at all. I didn't teach you, so so it was more the other way around. So apologies.
No, all good, all good. Yeah, thank you, Mitchell, and it's an honor to be in such good company, and I'd like to start the kind of the time for intervention I've been given with just thanking COSAs and all their lawyers and Zachary and your team for the absolutely incredible work that happened behind the scenes and then during the hearings, and kind of all the work also that happened afterwards and that has been done now, kind of really trying to amplify and uplift what has happened there and really celebrating the win, not just kind of as a commission, but with everyone involved and everyone who can be served by this very progressive outcome. So it was very special to be able to witness that. And the reason I've been invited is to speak today was because I was able to observe the hearings, follow the oral proceedings in Hamburg at the court with World's Youth for Climate Justice. We are a youth network that was inspired by the Pacific youth that has been taking the climate change case before the ICJ forward since 2019. they're the ones who, had approached the Vanuatu government, and then Vanuatu really championed this case, first in the Pacific and then together with Caribbean states and African states. And now we're in the middle of the commons phase, and that was referenced a few times today already. We are a youth network that is following, or that we very specifically kind of rallied governments around the ICJ case, but then these two other cases, of course, are very much, I'm sorry. I apologize for that. These three cases kind of very nicely work together, and it's some of our colleagues were able to go and appear during the Inter-American Court hearings as well. So really see that they can all be, pieces of the mosaic that we all are working on. I think something that stood out for me was the power of stories as well that were shared during the oral hearings. I think seeing young people as part of the proceedings, that is very, very special. And I think that is something that we've been kind of working on with other civil society organizations all throughout. And the ICJ case specifically is really uplifting these stories. And Joey was speaking about a platform that this offers. And I think that's what civil society organizations have been trying to do. How can we break these very technical legal proceedings down to a level that makes sense, and that really, that to young people, to those who were affected, but also those who can benefit. So there's, I think, kind of a lot of translation work that needs to, that civil society has been doing, that we also have to continue to do. I think we're extremely enthusiastic and happy, excited about, hopeful about what happened in Hamburg, and this really can be a tool, I think, for young people, for communities. Take that tool to support their negotiators that Joey had also mentioned, support their politicians, and really doing rights-based negotiations, using this as a tool, if need to be, for domestic litigation in other parts of the world, and really demanding states to follow up with these obligations that have been laid out so clearly. Joey was speaking about kind of regulations and legislative measures on a national level. This is something that we can do, and I saw that some of my classmates, for example, are here today. So this is kind of this is a gift that the court gave us, and now our responsibility to take that and run with it, and do something helpful with it. I think it really, I think we always say it's a tool in the toolbox. I think this is a very powerful tool that we've been given in clear words, and I think it's not just pairs, the all necessary measures element and the best available science. I think that is understandable even for non-lawyers, kind of very strong points that we can take and to build on. And I think something, and then this is really an invitation, I think, for everyone who's in the room, looking to The Hague when the hearings will be, and we expect them to be a couple of months after the deadline for the comments, so after August, a couple of months away from August. What is something that we can do? What worked so well in Hamburg? How can we support states to physically attend, but also how can we build a convincing, compelling story where we build on, and Delana, thank you for also bringing in an entire different advisor opinion as well. How can we bring in those elements, the kind of what we learned in Hamburg, to really kind of build a compelling case inside and outside the courtroom? And so it's an invitation to engage with us and all these actors who were involved in this case specifically. I think I don't, on the probably the most junior lawyer in the room, so I'll leave the legal arguments to the others, but I think it's really, Joy, thank you for really drawing out the fact that it's incredibly important that we utilize this platform for the public and the legal kind of work streams, and it has to go hand in hand. So I think best to leave loads of time for questions and engagements, but so I'm here to represent, I think, the young people and civil society who've been involved in the ICJ case a bit more than ITLOS, because it's a bit more technical, and yet I think Zachary, you and your colleagues really managed to engage and make, I think, a very, very clear case. And I've been re-watching some of Naima's pleadings before the court. And I was like, this is so clear. You would never have to have studied any law, and it makes so much sense. And I think hope that we can this can be an inspiration for all of us who would like to see this be successful going forward. Thank you, Michelle.
Yeah, that was great, and indeed, if you're more than welcome to speak for a bit longer as well. We've got half an hour or so until for questions and so on. So if you've got anything else you want to add, feel free. Because we've got some questions as well, just about your experience, perhaps of kind of participating within the ITLOS advisory, kind of as being as a member of the audience and so on. If you have any thoughts on that, and how kind of what was the feeling in the room, in the courtroom every day during those proceedings and so on. Would you be able to tell us anything about that? Were there other members of youth delegations and so on there? And did you get a chance to speak to them and so on? Was that something that you'd like to share with us at all? Or?
Thank you. I think it was what is incredibly inspiring also afterwards was the incredible uptake of what has come out there. And I'm sure Zachary, your team does this as well. We've been monitoring the press that has come out from there, and there's a lot of kind of academic legal writing, but there's also a lot of news outlets who've even, months later, like now, write about this. And it shows, I think, people are watching this space, and even when they didn't know that this court existed before, they know now. And I think that is extremely interesting. So it shows that court decisions are so powerful. It can be a very powerful tool and a very, very big piece of the mosaic. I think we learned a lot just kind of from attending the hearings. How can we make it engaging? One of Joe's colleagues is an excellent kind of translator. He does that great work on social media platforms, really explaining what is happening. I think that can be a really helpful tool as well going forward in any court case that concerns the public. I think we learned something there. I think on a practical level also a lot when there is media representatives in the room, what's the story that we want to tell apart from the legal stuff? I think that's very we've kind of been able to do some learning there. I think overall there's a lot of excitement in Hamburg in the best way possible. And I think we can also learn from. I think also one thing, and not to bring down the mood because everyone today has been really positive, I think the course in Hamburg is quite far out of the city, so it takes quite a while to get there. It's in the middle of a residential area, so there's also like not really any normal people who pass by or who follow what's happening inside. That's different in The Hague. It's in the center of the city. People know that this is a court that of international importance. But I think accessibility to international courts, that's a red line that we can draw between all of the advisory proceedings, that it is difficult for states, and especially for smaller states. And Zachary, if you're a team of 3 covering all of these proceedings in parallel, I don't know how you do it. So kind of doing that, even just physically getting to the courtroom, and then there's no lunch. So where do people eat if they do incredible work all day? I think it's things like that. And so now for The Hague, we're like, okay, how are people going to eat when the hearings will be happening for months at a time? I think it's very practical. It's accessibility to the courtroom. Also I can only imagine there are a lot of first-time participants, and there were some first-time participants in the proceedings before ITLOS. How do they feel going into that room? Where are they staying? Is it really far from the courtroom? What do they need the night before? How can we make this a less alienating experience, without, of course, kind of infringing on any discretion that states have in how they participate, or international organizations. So I think some kind of these practical things really stood out to me. But overall, I think it's encouraging to see how powerful the court has come out of this, and also German media that has never reported on the tribunal's work before. And I think a lot of people are realizing that there's a big arena there they had underestimated.
Yeah, I think that's super interesting as well. And I'm trying to, as the chair, I'm not trying to grill you too much as well. Just there's lots of interesting kind of snippets that are coming out here. And one is definitely just about the tribunal and where it's located. I did an internship there some time ago in 2018. I'd prefer if it was more relatively soon, but still, but even just the whole point about where it is located in Hamburg, it's located in a very wealthy area. It's far out. It takes time to figure out where you are, and again, I remember lunch as well. That was always a bit of a nightmare. It's actually quite difficult to find somewhere to even get something to eat. And I think it's important, because I know you participated in things like UNFCCC COPs and indeed the intersessional meetings in Bonn as well. I think that might be another comparator as well, where these buildings are quite, the UNFCCC Secretariat is a bit out of town, and it's not really, it seems quite out the way. I think a lot of friends have always asked me why on earth I was going to Bonn in the first place, because they know what COP is, but they don't know what these intersessional meetings are. So but then when there's this larger group of youth that are participating in this, there's lots of help and there's lots of camaraderie. There's social media things as well at COP saying, you don't go to every single side event. You need to look after yourself if you're going to last this marathon of 2 weeks. And court proceedings are very much the same. And I think it's good to kind of reflect on that as this ICJ opinion comes as well. Being like, how can we take this approach of youth solidarity and climate justice that is on display at the UNFCCC, and how can we translate that then to participating at the ICJ and so on. So I think that's really cool. Now, Zachary, you've got your hand up as well. So would you like to?
Yeah, I wish to just add, from my perspective, as the first time participating as a country before any of these tribunals, it was very much I would use the word harrowing experience, trying to figure out just how to submit written submissions to the ICJ. That was a month-long process because we don't have representation in The Hague diplomatically. And then a lot of our neighboring countries also don't have it as well. So there was coordination between Caribbean countries, trying to see who would be arriving on what dates, where we could pick up what from which printer. It was an interesting experience. But a point I'd also like to make very quickly and very shortly is that I find with the advisory opinions, it more mirrored negotiations than litigation. And I thought that was very interesting in the sense that litigation is usually very adversarial, whereas with the advisory opinions, we saw a lot of smaller groups coming together, whether it be small islands, whether it be Global South, whether it be OACPS. And we were actually, discussing our points, how we can respond to different arguments being made. And that was, one, fascinating to me. And two, it was very helpful with overcoming this just voluminous burden. And the second point I wish to make is that the role of media is so much more important with advisory opinions. And in my own reflections, I have equated it more so, or rationalized it in the sense that in litigation, the litigants want to know what their rights are. So they are very keen to attend whatever dates to make sure that their submissions are done, to make sure that the evidence is forward, following, when next will we be in court. But with advisory opinions, a lot more, when I speak to persons, I hear, oh yeah, there's a climate change thing happening. And a lot of persons don't necessarily go further than that. So the role of media, the role of young persons, the role of translators, making the legal aspects digestible for the average man, I think is really, really important and key. And we have seen the benefits from that in our, whether it be COSIS, whether it be AOSIS, whether it be Vanuatu and the like-minded states. We've seen the benefits in our engagements thus far.
Excellent, that's great. Does anyone have any sort of burning interventions, or I might just we've got a couple of questions in the chat, but I kind of want to draw on certain points in the panelists, just maybe abusing my position as chair, maybe drawing out information to enrich the webinar, whichever one you want to pick. I'm maybe doing both, but because Joy, I noticed you answered one of the questions already in the chat, and this was more about this very strict textual reading of, say, the UN climate regime and the Paris Agreement and everything. And I know CO obviously working on children's rights and children's rights to a healthy environment and so on. And I just wondered whether, I'm just thinking about kind of general comment 26 in this under UN Convention on the Rights of the Child kind of coming out, and how this has actually quite helped bolster, say, children and youth participation and consideration of children and youth within climate change obligations, and how actually maybe the advisory opinion might follow a similar suit and be kind of read together, if that makes sense, with bringing the ocean into the climate change regime. we're bringing all that stuff together as well, like we do at the hub, and hopefully that made some sense there. But if not, then just let me know and I can try and clarify that. Joey, did you want to chime in there, or?
Yes.
Sorry.
I would ask you to clarify the last bit of the question.
I think there's a lot of thoughts there as well, and I know I should probably write down the questions before I ask them. So you answered a question already in the chat, so I just wondered if you wanted to elaborate on it a little bit, just on this the idea of this of that we should really only kind of read the Paris Agreement and the UNFCCC kind of together, and that should just be on its own and separate, and the ITLOS advisory opinion maybe. Or any other legal developments, perhaps, or policy developments that happen elsewhere, even if they relate to climate change, shouldn't be brought in. So I'm thinking, for example, the ITLOS advisory opinion here that we're discussing, and then also something like General Comment 26 on kind of children's human rights in the context of climate change, and how some might say that those two developments actually shouldn't inform negotiations under the UNFCCC or the Paris Agreement.
Oh yeah, that makes no sense to me. I mean, yes, and I will respond to that specific question, but I do want to very quickly touch on something that really inspired me from what Eula and Zachary mentioned. That it is, I mean, I found the COSIS oral arguments before ITLOS to be absolutely just beautiful, so moving. In fact, if you go to the ITLOS webpage and the climate one, I would really, if there's one thing, please read the advisory opinion itself. But if there's one thing you should read, it's the first 2 days where there's verbatim records where ITLOS's oral arguments are laid out, because I watched those and honestly, I was moved to tears. That is making what is relevant and I've done I mean, I've litigated for 20 years and I just thought that was so beautiful. That is what we want, because we were so lucky. We got an incredible, not lucky, we had incredible lawyers like Zachary and his team behind it, but we got a great opinion. We may not get a great opinion. I mean, I'm very hopeful, Alana, about the Inter-American Court. But at the ICJ, I mean, we're very hopeful and we're pushing so hard. And, you know, there are so many lawyers, including Pacific State lawyers, who are doing an incredible behind the scenes push to make it as strong as possible. But we're not. But what matters is the narrative that we are creating. So what happens is not just within the courtroom. What we're doing outside matters so much, building these narratives, bringing these connections. And what we get from the courts we get, and what we have is a strong foundation to build on in campaigns, in other cases. So like the World Youth for Climate Justice, I mean, I'm sure all of you know that they do incredible work. But one of the things they're doing, along with the Pacific Island Students Fighting Climate Change and many other campaigners around the world, is doing this big push around the oral hearings to make it relevant, not just for what is happening in the courtroom, but to mobilize around that and to make this moment relevant. And that is so important. Young lawyers are watching, campaigners are watching and asking questions. Okay, what does this mean? And whatever outcome happens in the court is something that we should build on. And that can only happen if we're creating this narrative through our campaign work, through our conversations with each other and in the media. So I think that's great. On the negotiations itself, what I have seen when I've been at COPs, and I'm sure Zachary and others, Alana and others would have insight as well. There are many times legal questions come up in negotiations. And what is really upsetting is sometimes some states will pretend as everything is being negotiated in the moment, in the here and now. No, certain things are there. You have obligations under international law. This is not something that needs to be talked to death. Just live up to your obligations, or say that we are not in compliance with the law. Not everything is being decided now in this current COP, and that is the kind of impression you get. So when you go back and you take up my recommendation, I really hope, and you read those verbatim records, you will see these absolutely powerful statements from small island state leaders, where they were talking about, we have shown up in every COP, we have given it our all, and we have seen that. We have seen the dignity and power with which small island states show up every single COP. They do so much, and every priority that they have is just pushed aside. So the legal clarification, they talk about this, that, we just want the law to be clarified, and this will help clarify the discussions we're having at COP. So they're absolutely not in conflict. These are not external to each other. It's a driving force. And of course, it'll go beyond COP and beyond UNFCCC and Paris, but it will be absolutely central to breaking the deadlock that we often see in core arguments and human rights questions around carbon markets, around indigenous people's participation, around gender issues, around loss and damage, questions of the state responsibility law. They come up behind the scenes in negotiations all the time. These advisory opinions can actually be a game changer. So yeah, very much something to keep in mind that, you know, as many people have said, all of this works together. They're not at all in silos. So
excellent. Thanks so much. And as apologies, didn't understand my framing of the question, but you said exactly what I wanted you to say. So that's the best. That's the most important thing. So that's good. So so if anyone's got any interventions just now, otherwise I can kind of turn to the Q&A here as well, because there's a couple of unanswered questions. So so I'm gonna pick one here, and this maybe goes then back to the Paris Agreement, and let's yeah, let's maybe kind of focus on that just for a second. But do we think this reference to the Paris Agreement, or this inference that the Paris Agreement is, you know, is not the only area or the only source of law in this context here? Do you think the reference to the Paris Agreement not being sort of lex specialis kind of minimizes or undermines the Paris Agreement itself? Does anyone have any thoughts on that? I think we've kind of touched on this already, but I just wanted to see if anybody wanted to. Yeah, Zachary, sure, please.
I mentioned it before in my earlier intervention, that I believe the Paris Agreement, the advisory opinions, all treaties of international law, all sources of international law are really a mosaic that explain what are the obligations of states. But I think this is a very interesting question, asking what is the effect for UNFCCC? Because up until this point, I've never really thought about the effect on the Paris regime. I've always been thinking about the wider scope, which would be more beneficial to states. So thank you very much, Anna Cabela, for that question. And in answering that question, I think I would say that I believe it doesn't undermine or minimize the Paris regime. And why I say that is because I think what a lot of people must remember is that treaties are really reflecting an agreement of states. So I believe that the UNFCCC, the Paris Agreement, was created for a specific purpose to reflect specific rules and obligations. So to my mind, the advisory opinion identifying that this is not the only source of international law that governs obligations doesn't undermine what the UNFCCC regime was intended to do, but rather it just indicates that along with this regime, there are other obligations that you must comport with. So that would be my answer on the fly, having not thought of it before, but I'm happy with that.
Yeah, excellent. Does anyone else feel the need to chime in just now, or should I jump to another question? That's okay. So we've got another kind of a couple of other kind of slightly more complicated ones, and ones that are quite focused on human rights as well, which is great. But I'm going to go with the first one on my screen here, and this kind of relates to sort of the law of armed conflict as well, and UNCLOS's sort of role in that in the context of climate change. So I'll read this out in full, and then we can maybe unpack it. Okay, so and this is an anonymous participant that's asked this. So hello, if you're still there, we're answering your question now. So does the tribunal's advisory opinion have any impacts on obligations of states involved in armed conflict, near seas or oceans, in terms of regulating heavy greenhouse gas emitting ammunitions, or, and I guess like military activities in general? Obviously, this could have human rights connections to Geneva Conventions and regulating armed conflict. So I don't know if anyone's kind of got experience in the law of armed conflict there at all, or whether we want to unpack that. Joey, you've got your hand up. Excellent. Please.
I'm happy for others to chime in as well. I am not an expert on the law of armed conflict, but we have been responding to a lot of questions. So it's really interesting to see that after the ITLOS AO is delivered, many folks from many different areas, whether that's people working on the plastics treaties or people working on countering marine geoengineering, are asking that, what does this specifically mean for our areas of work? And the question is, I guess, that it depends. So there are two kind of primary pockets, and massively simplifying, and Zachary, forgive me for this, but there is the obligation to protect and preserve the marine environment, and then there's the obligation to prevent, reduce, and control marine pollution. Now, the tribunal has very clearly laid out what marine pollution is constituted, that there must be substance or energy, that this must be introduced by humans directly or indirectly, and that such introduction must result or likely to result in deleterious effects. So basically, if you're looking at a particular area and trying to see, okay, will the ITLOS AO apply in certain cases, and can we draw on it for state obligations, one of the things to do is to check whether, for example, these armed conflicts are leading to something that we can constitute or make the legal case for, that this does constitute marine pollution. And there might be a strong case for that, right? So that is possible to argue, or alternatively, that it creates degradation of the marine environment. So I definitely think it's going to be an application of the law. And, I don't want to speak out of turn without having thought about it or thinking about it, but it's really making that application. And I could see that it could potentially be made depending on the specific facts and, the scientific evidence, and looking at whether these two kind of aspects are met. And then absolutely, then the different holdings of the opinion would apply, but it would be fact specific. So I'll stop there.
Yes, indeed. I think this one's quite a complicated one as well, especially with UNCLOS kind of supposedly kind of being focused, or kind of being focused on peaceful uses of the sea, but then we have this, unpeaceful, like wartime activities are still causing issues as well. So it's a complicated one, and definitely one that one should consider doing, say, a master's or a PhD on as well, because I think it's obviously on the minds of quite a lot of people, given what's going on in the world just now as well. So I'm just going to touch on, there's another question that comes around the issue of sort of behavioural change, and we hear this quite a lot in the kind of climate change discussion as well. And so Matthews is asking, freedom of thought is an absolute right under the ICCPR. And one way to mitigate climate change is by changing the behaviour of population. So a mass behavioural change initiative may interfere with their freedom of thought. So does anyone know, is there any study or research the panel is aware of regarding this issue? And so I don't know if anyone's got any thoughts of that. Anyone that's more focused on human rights is familiar with this behavioural change aspect in climate change, or? Okay, so we'll maybe take that question just offline, and we'll try and answer it a bit later on. I think it might be quite a complicated one to ask at the moment. And so and then so we've got a final one here as well that relates to biodiversity as well. So kind of moving more back into the kind of strict matters of today. So are there are there any responses, or what would be your opinion on the main findings which could be extended to also protect biodiversity from climate change, and also from other contaminants or even other impacts? I mean, some examples I think would be quite useful, but I think a lot of us might be of the view that or certainly of the view that marine environment includes marine biodiversity. I think that the tribunal was quite clear on that, and then arguably, I think efforts to protect marine biodiversity from climate change by reduction of greenhouse gas emissions and so on would then protect biodiversity on land as a whole. So I don't know if anyone else has other kind of thoughts on what the tribunal said about biodiversity as well. I mean, I did a quick control F there, and it comes up quite a lot during the discussion of the science and the engagement with the science as well. And the Convention of Biological Diversity certainly gets mentioned an ample few times, especially with regard to definition of an ecosystem and so on. So which it includes its biodiversity, of course. So I don't know if anyone else had any thoughts on that. Or
I think the other additional point, sorry, you hearing me?
Yeah.
I think the other additional area with respect to biodiversity that's going to unroll and have added significance in the next coming years will be biodiversity beyond national jurisdiction, because the way in which we address and share the benefits, for example, as well as the role, as I mentioned before, the expressive role of indigenous peoples and local communities. So haven't really thought about it until just now, but I think that the ITLOS advisory opinion will also influence how the development of some of the aspects of the BBNJ agreement as it rolls out, because as we know, it's now getting started. So that's one of the things that I would think of. Drawing linkages also with regional Cs programs, because we have quite a few regional Cs programs in the Caribbean region, in the wider Caribbean region. The Cartagena Convention is tremendously important, not the least because it was the basis of the question that Colombia asked in Advisory Opinion 2317. But the most regional Cs agreements have a general structure which includes specific agreements on biodiversity. So they're also I suppose law that can be generated from a regional perspective that can also combine with under the law of the sea, as well as the Biodiversity Convention. And I would say it would become increasingly important, especially as we've seen a deepening of the linkages between the Climate Change Convention, Paris Agreement, and the Biodiversity Convention in the context of nature-based solutions, which none of the least are tremendously important for most coastal communities, and including small island developing states. So having not thought of it before, I think those are some of the linkages that I would off the cuff make in that regard. And of course, as Michelle, which is your area of specialty, it also has implications for fisheries law, which again is circling back, is very vulnerable to climate change, is also important for communities, including global South communities, which are heavily reliant on fisheries.
Yeah, for sure. And I'm really glad you brought up regional seas agreements and of course fisheries as well, which is my thing, because of course, you know, it's important to understand there was all this discussion on cooperation as well. And that's just not, you know, between two states. That will be done in regional approaches, as UNCLOS is kind of specified, and the international community has decided is important. So so that's great. Now we've got a couple of other ones. I'm just going to try and field a few, because I think there's one here that I want to keep kind of for the end as a kind of last as a last hurrah. So the second one I've got in front of me, and this one this will always happen when we discuss climate change, is the matter of the United States as well. Okay, so this is quite a long question, but I'll read it out as well. But you know, what impacts might the advisory opinions have with respect to the policies and the decisions of the United States, the biggest historical emitter and the largest producer of oil and gas in the world? Especially considering a potential upcoming change in administration, with the US expected to pull back out of the Paris Agreement and indeed even the UNFCCC. It seems very challenging to hold the US accountable for its climate contributions under domestic law and under international law. So conscious of the kind of sensitivity of the question and the fact that this is being recorded as well. So if anyone wants to chime in on that matter or not, it's totally up to them. We will see. No one's putting their hand up or not. The US kind of generally will always come up. I mean, yeah, Joey, that's perfect. Thank you.
I'm happy to try. It's a very big question.
Yes.
And if I'm not mistaken, the US is not a signatory to UNCLOS, right? So it was not part of the, although from what we understood, it did still have conversations with states behind the scenes. The US is very much engaged in the ICJ process, and there is heavy confidentiality, as we know, around the ICJ written submissions at the moment. But from what we're hearing, there are some very, unhelpful arguments that are being put forward, and there is also just the geopolitics at play in terms of even the comments period and who feels comfortable taking on the US openly, which is also, and this is a really important thing as well, to keep in mind. One of the good things about court proceedings, whether they're AOs or national level court cases, as opposed to climate negotiations, is that there is a lot of bullying in a way that goes on in climate negotiations behind closed doors, very heavy-handed, this is what we want. And in a courtroom, you are forced to air your positions publicly. You have to say what you're going to say if there are oral arguments. Your submissions are made public at one point. So I think this is an important tool in the hands of campaigners. Regardless of what we do, we know where they stand. We can hold them accountable through campaigning. The US is right now in such a difficult space. The Supreme Court is in such a difficult space. But tides change, and we can keep fighting, and we can keep doing what we can, and we can keep laying the foundations for when the time is right to pick that back up and do what we can, fight in state courts where we have more progressive state courts. There are different challenges, but nobody, I think Dana raised this question, is disputing that this is a really difficult time right now for the US, and that we keep on with the fight because we have to.
Absolutely, that's great. Zachary, you had your hand up briefly there, or you?
I'm literally, Joey took the words out of my mouth.
Oh, okay.
I believe I was going to say that tides change as well, literally the same language, referencing the ocean, of course. And honestly, I think the US, it's a peculiar position. I wear the hat of both a lawyer and a diplomat for my country. So there's nuance in how to answer this question from the Antiguan perspective. But I will say that in my view, in my personal view, I think American citizens are the ones who will ultimately hold most power as to how America changes their actions in the future.
Excellent. Okay, now I'm conscious of time here. We've got about 2 minutes left, so I'm gonna wrap up, and I'm actually gonna put Julia on the spot. Okay, because one of our attendees has asked, how do you think adolescents can protect their environmental rights? So Julia, I'm going to ask you first, and then we're going to go around if anyone wants to add anything, and then we'll wrap up. Okay.
Thank you. I had seen that question, and I was worried you were going to ask me this. No, thank you for that question. And I think I've drawn so much inspiration from the Pacific youth and all the youth who has joined working on the ICJ case, on ITLOS, on the Inter-American Court. There was a lot of young youth organizations who had engaged. I think it has to be clear to young people, and I think that's our responsibility as civil society organizations, that what we're doing here, we're not begging, we're not asking for anything. We know we're entitled to our human rights, the right, of course, the right to life, that's the most foundational, but also, the right to food, the right to receive an education, the right to housing. There's so many, political, civil rights, but also what we say socio-economic, right, social and economic rights, like rights that you have as a person, that you can ask your governments to provide for you. And I think that has to be clear. That will come with climate education, to which you're also entitled to. And within the UNFCCC, there's conversations on action for climate empowerment, so really kind of providing climate education to people. So I'll be done in 2 minutes.
Okay, thank you. It's been interrupted. So, Alana, do you have any thoughts about how adolescents can protect their environmental rights?
Well, I think speaking from the region where I'm from, one of my laments is that we're not as active in my region as we should be. I think one of the critical things, picking up on what Jules said, is the literacy and awareness of issues. I think that's a critical area, which, as you said, it's owed to children and youth as a right. And I think what the benefits of it will be that not only will this greater awareness and literacy filter into policy laws, but also the political process. The bottom line is, wherever you are in the world, political powers that be respond to vote. Unless, of course, you're not in a democratic state. I don't know. once we begin to see changes in not only policy and laws, but also how the population views certain matters, we will get change. And that is, to me, I always advocate while we're doing, and this is tying back to what we've been saying, these are various tools. So we have negotiation, we have the advisory opinion. At the same time, we also have to invest in our youth and what they can bring to the table. We cannot have to chew bubblegum and walk at the same time and think long term, because we are at such a critical point that even some of the mechanisms we are asking for in these advisory opinions and in negotiations will need to be sustained over a long period of time. And I see the youth and children and even the future generation as critical to that.
Excellent. Who wants to go next before we wrap up? Zachary, Joey, do you have any thoughts about how youth can, or adolescents can, or youth can protect the environmental rights? Zachary, please.
Yeah, so I'll just quickly add, I agree with everything that's said thus far. And myself on the outskirts of the youth bracket, I would also add that I think being new to the legal fraternity myself, I was called in 2020, so I haven't been a lawyer for very long. But I think something that the youth, especially youth from global South states, from small island developing states, that we have a unique ability to give our experience. And I have noted the more that I've engaged in these advisory opinions, negotiations, etc., it is really only a story that you can tell. And we should be able to more utilize that ability, because due to no fault of their own, some persons may not understand the effects of a Category 5 hurricane bearing down on your country within the next couple of hours. Some persons may not be able to understand a flood relocating a city of millions of people. But that is something that if you have lived through that and you have experienced that, you can share those stories, share those experiences, and that will hopefully inform others and how they go forward with their behavioral changes. So my advice to the youth is always be able to speak your experiences in a sense that you're able to translate that to other persons.
Thank you so much. That was excellent. Joey.
Well, I think we should end on that. That was so powerful. But
Yes,
I will say,
exactly.
but I mean, as somebody who's very far from youth at the moment, I have to say I continuously draw inspiration from the powerful efforts. And what I've seen as a human rights and movement lawyer over the years is that those most affected lead the most powerful fight. And I see that with the youth. I see that in that energy, the vision, the brilliance they bring to the work. So they are leading the fight, in fact. So yeah, much gratitude.
Absolutely. Well, this has been incredible, and I guess I think from my experience, just to finally add in and just to of course agree with everything that everybody has said as well. This ability to share experiences and knowledge and procedural aspects of, say, how the UNFCCC negotiating system works way better than you could ever get out of a textbook, just from being organised and sharing these experiences and so on is incredible, and the amount that can get done through youth participation and activism, and for me has just been amazing. So I thank all the participants today. I thank all of our panelists. Unfortunately, Eula had to leave a few seconds early there. But everyone, this has been a really tremendous experience, both in terms of academic discussion on human rights, and just from kind of being together and kind of sharing our experiences and our thought on this advisory opinion. So for everyone, look forward to seeing you again soon at some point, working together and so on. And I think we'll bring this webinar to a close. So thanks very much, panelists. Thank you.
Thank you, everyone. Thank you.
Bye.